Okay. Does that conclude your opening statement?
Your Honor, at this time, I would like to, I have someone here that has written an affidavit, and we filed it in our pleadings. I would like Ms. Cynthia Cantrell to discuss her affidavit.
To be called as a witness. Just to be called as a witness.
To be called as a witness?
Okay, well, plaintiff, do you have any witnesses to be called?
No, Your Honor, John.
Okay. Normally, Mr. Sontag, we don't allow witnesses in a forcible attainder. Okay, then you just hit him. So, Your Honor's going to deny me a jury trial and my right to witnesses? How many constitutional rights is this court going to deny me right now? And I would just say it like that.
Okay.
Go ahead.
So, Your Honor, you're telling me that this court is denying me a jury trial, and it's also denying my ability to call witnesses. I didn't get the word.
How many of my constitutional rights are you going to deprive me of right
How
now?
many of my constitutional rights are you going to deprive me of?
Now, Mr. Sontag, do not get smart with the court. Okay. Okay, go ahead and call your witness.
Okay.
Are there any objections?
No objections, Your Honor.
Your Honor, I call Ms. Cynthia Cantrell to the stand. She is an expert.
No, don't start with that shit.
Okay.
Let her do the talking.
Okay.
Call your expert to the stand and leave it the fuck alone, people.
Okay.
Get up here.
You want me up there? Okay, I thought I had to be near this.
You're fine if you're right there, I think.
Oh, okay. All right, you'll just...
Right by the mic.
Yeah.
Okay. All right, Ms. Cantrell, you're now sworn in, blah, blah, blah. All right. She's your witness, Mr. Sontag. Go ahead and question your witness.
Your Honor, for brevity's sake, could we just allow Ms. Cantrell to tell the court what she does and to explain the affidavit that she made?
Is there any objection?
Your objection, Your Honor, we haven't had any notice that witness was going to be here from Mr. Sontag at all. So,
I object, Your Honor.
and we
I
have
object,
no
Your
idea
Honor.
if she's going to be qualified. Let's get her up there so we see if we can qualify
Yeah,
her.
no.
Let's see what her experience is. But we have no prior notice of her being.
I have it in the
Your Honor,
pleadings.
Your
You do?
Honor,
Yeah.
Well, he also didn't object to her coming in.
Yeah,
first place, so.
yeah. It's already in the pleadings. I'm not sure why. I think you just missed it.
All right.
So, barring any further objections, Ms. Cantrell, go ahead and we're in the interest of brevity. We're going to go ahead and just let you make your statement. Go ahead.
Thank you, Your Honor. I was hired by Mr. Sontag to prepare a report as to the current foreclosure documents from his deed of trust, his adjustable rate note, any assignments of deed of trust, substitution of trustee, and notice of sale documents, and to look for breaks in the chain of title to ultimately conclude whether or not the entity attempting to foreclose on him in this case.
Ms. Cantrell, I have no idea why he would ask you. Why did he ask you?
Why did he ask me?
You haven't told us who you are.
Oh, well, I thought we've already gone through that.
Oh, okay.
When you-
Just say you're a certified title admin. Okay, all right. We understand that now. Please continue.
Okay. So anyway, I was able to review the documents, and I have prepared an affidavit as to my findings. Pursuant to the deed of trust, that's the first document I examined. The deed of trust had a dated date of June 22nd on the first page, paragraph 1, I believe it is. Pursuant to the document, it was notarized 4 days later by a Glenna D. in Nevada. Now, the issue is that the document, the deed of trust, has a date on it of June 22nd. However, it was notarized supposedly 4 days later in Clark County, Nevada. And the notary claims to have personally acknowledged the signature of Karen Sontag, his wife. on the 26th. On the 28th, another notary claims to have personally witnessed Mr. Sontag's signature on the deed of trust. That would be 6 days later. Now, the issue being is that the deed of trust is claimed to be dated on the 22nd. How could the notaries have notarized the signatures of these two individuals 4 and 6 days after the document was signed? Either the notary has notarized the document without the signer being present, or what we have is we have a document that was not signed as it is stated on page 1.
Plaintiff, you're not objecting, or do you
Well, I just
have-
wanted to, I've got a lot of questions to ask you, Your Honor.
Okay, so you're waiting for your cross?
Yes. Is that the right time to add to?
Well,
add
no,
the
the right
cross?
time is to object while she's making statements, but
Okay, well, I wasn't aware.
But
I'm a bad
we
attorney.
will blow that off. It'll
Okay.
probably happen if do this tomorrow. Okay, continue, please.
Okay. The issue being is that the deed of trust is evidenced by the adjustable rate note. It says so in paragraph E, that the note means the promissory note signed by borrower and dated June 22nd, 2007. Now, I reviewed the adjustable rate note, and there is no additional dates on it. So the date of the adjustable rate note would be June 22nd, 2007. It's not notarized, it's signed on that date. So for the deed of trust to be evidenced by the note, that means the deed of trust would have had to also be signed and dated on June 22nd, but in this situation it was not. It was signed on 4 and 6 days after the fact, pursuant to what the notary is attesting to. Therefore, that deed of trust was not with that note. Pursuant to Carpenter v. Longham, case of 1872, which has never been overturned, the deed of trust may never be apart from the promissory note, and the fact that these two documents were dated different dates would prove that they were never together to begin with. So
So
that
are
would
you-
validate the deed of trust in this matter. Moving
Okay.
forward,
Plaintiff, do you have any evidence that the deed of trust and the promissory note are together? It's a yes or no question. Do not take me in circles.
No, Your Honor, I do not.
Is it your contention that the deed of trust and the promissory note are together or are separate currently?
They are separate currently, Your Honor.
The case dismissed.